Hello again, this is Jim Rooney. In this session I want to go through 42 questions with you. These are questions that continually are asked of me by clients when they come in, and I hope that they prove to be helpful to you. Necessarily I'm going to use the YouTube 10-minute increment, so unfortunately it all won't be on one film and you'll have to follow through sequentially, but I think it's well worth the time. These are questions, again, that just come up all the time. First question. My husband and I have a joint checking account. Either of us can write checks on the account. My husband deposited his paycheck into the account, and a judgment creditor of mine attached all the funds. My husband owes no money to this creditor. Can my husband recover the money that was taken? The answer is yes. This happens quite frequently. The garnishment or bank account attachment notice that went to your bank, it only had your name on it, and the bank should have never attached a joint account to begin with, but they frequently do. And the reason they do is they get by with it. They have bank policies, and they'll tell you what's our bank policy to do that. Well, their bank policy is inconsistent with the law. If you will hire an attorney, that's a wrongful attachment, and what you need to do, a wrongful bank attachment, what you need to do is file your spouse that doesn't owe any money needs to file in your collection lawsuit a motion to quash, and then I would also have that same attorney file a lawsuit against the bank, because you undoubtedly in most instances would have incurred bank service charges because of them grabbing all the funds and you having NSF checks floating around. So go ahead and do it, and I teach your bank a lesson. Social Security funds. This comes up quite frequently. Social Security funds are exempt from attachment. So if you will file a motion with the court that issued the garnishment and show them that funds that went into that account were Social Security funds, then you're going to get your money back. Now, we also, interestingly, have some case law here in Missouri that says that, let's say you had $500 in the bank account. $300 of it came from Social Security. The other $200 came from somewhere else. You're not required to break out where the money came from. Here in Missouri, if any of the money came from Social Security, then the entire amount was a wrongful attachment, and it should be returned to you. So be sure to follow through on that. That's a real shame when that happens. It's also a nuisance. Whether you get the money back or not, you still have to go to the trouble of proving up that they were Social Security funds, at least in whole or in part. Number 2, my wages were garnished. If I file bankruptcy, can I recover the monies that were taken? This, of course, happens all the time, and the answer is, when your employer was served with notice of the garnishment, you need to look at a copy of the garnishment notice, because there'll be a block there that was filled in, and it'll have the return date. You need the return date. That's when your employer is supposed to send that money in to the court. So as long as you file bankruptcy before the return date, then the money will be returned to you. Now, we need to claim that, the money that's being held, we need to claim that as an asset on your bankruptcy and then protect it with an exemption. But the key date is the return date. Now, another thing I want to forewarn you about is garnishments frequently are issued for a 60 or 90-day period. Your employer is supposed to hold all the money that comes in as a garnishment for that 60 or 90-day period and then mail the money into the court at one time. Well, unfortunately, a lot of employers do not want to be holding that money, so they will mail the garnishment money in every week or how often you're paid. You need to get with your personnel department and tell them or ask them not to do that. Tell them that you are going to be filing bankruptcy and you're asking them to hold the money until the actual garnishment return date. That's real important. Bank account attachments are the same way. As long as you can get it before it's paid in to the court, then we can claim an exemption on your bankruptcy and get that money back for you. My vehicle, question 3. My vehicle was repossessed. Is it too late to get it back? The answer is not whether the car was picked up on a repossession, but whether or not it's been sold. As long as we get notice to your creditor before he sells the car, then you can get it back if you want it back. One of the problems that frequently comes up is you may have moved several times and the lender does not have your current address. So when they send out the statutory notice that's required to give you notice that the vehicle is going to be sold, it'll go to the wrong address and you won't get actual notice. You be sure if your car is repossessed, you be sure that your lender has your correct address. I'd send them a fax proving that, so that you can prove later that you gave them notice of your actual address. I am married and want to file bankruptcy. My spouse does not want or need to file. Can I file? This is coming up more and more frequently. One, within your bankruptcy you need to qualify on income. How much income is coming into the family. If you and your spouse live together in the same household, then your spouse's income needs to be included in your income computations, and it doesn't make any difference whether your spouse isn't filing. His or her income is going to be included as part of your eligibility for filing bankruptcy. Another thing you need to know about this, let's assume that you and your husband, even though he's not filing, let's assume that you and your husband have a number of non-exempt assets. Maybe you have $50,000 equity in your home, or you have cars that are jointly titled and they go beyond the exemption limits. Well, in bankruptcy, your creditors, let's say you just owe the money, your creditors cannot reach those assets, those jointly owned assets, because your husband, of course, does not owe any of those debts. So there's a special exemption beyond the Missouri exemption. If I'm your attorney, we're going to use a federal exemption that will protect you in that situation. Now, here's where the problem is, a potential problem. Let's assume that your non-filing spouse also owes those same creditors. In that case, the bankruptcy court will use any non-exempt assets that you and your spouse own in order to pay those creditors. So you want to make sure that you visit with me or some other competent attorney and make sure that you're filing and not endangering your non-filing spouse because of non-exempt jointly held assets. Do I need to list all my creditors on my bankruptcy petition, including those I intend to pay? This comes up all the time. Almost every case comes up. People say, well, I know I'm going to pay such and such creditor, therefore there's no need to list them in my bankruptcy. Well, it's a statutory requirement. You have to list all your creditors. Now, as I've mentioned, I think in a couple of parts in this series, after your Chapter 7 bankruptcy petition is filed, you can pay anybody you want to. There's no restriction on that. What I frequently do for my clients, if they have that situation, is when I file the petition, within a day or so, I will send a letter to your creditor, the one you intend to pay, and I will identify who I am, of course, and then I'll say, my client has informed me that they intend to continue paying you. You were listed in their bankruptcy petition because of a statutory requirement that they do so. And almost all creditors will understand that. Now, it's different if you're filing Chapter 13. In Chapter 13, your unsecured creditors are all deserving of being treated fairly and equally. So in a Chapter 13, you can't do that. You have to pay money into the court, and all the money is paid fairly and equally, pro rata, to all your unsecured creditors. So there's a difference here between Chapter 7 and Chapter 13. What are the most frequent mistakes that debtors make? This is a situation where frequently you don't want to list a creditor because or an asset because of a family relationship. We're going to hit that in the next video.